There you go, family. DJ Hilson. Straight Talk with DJ Hilson is in effect.
Look at that, man. You know, this is what I love about technology. It's really, and I never know if I'm sending Rob a text too early in the morning, but I figured, you know, 8 o'clock isn't that early, and shoot him a text saying, you know, hey, can we go remote? And voila, by 5, we are rocking and rolling. And he even had time to, you know, kind of clue me into some of the things you wanted to talk about today. So I appreciate that very much. And I always laugh at that photograph that you throw up there. I mean, I want to know what year that was, because I recognize, I don't think I own that tie anymore. I don't think I own that dress shirt anymore. So I'm curious to know, you know.
Yeah, I don't know where I found that. That's one that it's in our database, but I do have another one that I'm gonna start using that shows you in your real element in the court, and we can start using that one.
Oh.
There you go. Got the PowerPoint thing going on.
That looks like a guy that is just really serious right now, and he you know, is trying to convey a message. That's for sure. Yeah.
So DJ, I know you and Rob, he got soft because I don't like prepping. I don't like prepping you guys. So DJ should know. He should know law. You know what I mean? You should know Michigan law.
Right. You know, I should know the hundreds of penal codes at the top of my head. You know,
and you do.
Yeah. Listen, that's very kind of you to say, but you know, when we're talking about some of the more obscure law, I need to at least familiarize myself with it. So I appreciate the heads up.
So you don't. So do you know like every criminal penal code? Is it too many?
Well, I mean, you know, I certainly know some of the more general, you know, some of the ones that we see on a regular basis. You know, you certainly commit those to memory, and you know, some of the more obscure ones, maybe, you know, that you may have come across once or twice, but it's so obscure that you don't forget. You know, I may know, you know, kind of the not the title, but the topic, and then try to scramble around to make sure that you find the right statute that goes with that particular topic. But yeah, I mean, you know, look, if you do anything for, you know, a long time, you know, a lot of stuff does get committed to memory. So, I mean, it's just the force of habit.
Right. Right. Have you been watching the Derek Chauvin trial?
You know, I've had some opportunity over the last 2 weeks I've got a TV in my office, and I've had it on days where I've been doing a lot of desk work, which haven't been that many, but I've had a chance to watch bits and pieces. You know, there's been parts that I'm really upset that I missed, that I really wanted to see and just got busy and wasn't able to watch it. But yeah, I've watched bits and pieces of the prosecution's case from day one through, I think I watched a good chunk of the cardiologist's testimony yesterday on TV. And so I'm going to try to block out Monday. If in fact they're going to do closing arguments on Monday, I do want to watch all those in their entirety.
Oh, on Monday. Oh, wow. So the defense is not going to have too many witnesses.
Well, you know, I don't know that there's, you know, that was the speculation yesterday. They were arguing some motions prior to bringing the jury back in yesterday morning. And the judge mentioned something, you know, if we're going to be closing on Monday, and who knows, and maybe they're set to that, so it gives them the weekend to kind of put it all together. And if I were, you know, certainly the prosecutor in that courtroom and the judge said you get the weekend to work on your closing, I would like bow down and kiss him, because, you know, you got all that information, and you think about it, you're trying to, in a closing argument, you're trying to summarize what the jury has seen over these last 2 weeks. Mm-hmm. And, you know, we're all human beings. And so, you know, the witnesses that you heard on day one and day two, you're not going to, unless they're taking notes. I don't know if they are allowing the jurors to take notes or not, but even if they are taking notes, if you missed something that was important to the prosecution's case, you know, it's important that you go over that. And so, you know, I certainly would appreciate having a few days to kind of gather all that and figure out my strategy, and then lay it out certainly in a fashion that I felt, you know, was going to be, the jury was going to be receptive to, and that they were going to be able to follow along and see, you know, the path that I was leading them down. So yeah, I mean, I'm hoping that regardless of whether they finish up this week or not, that the judge just gives them the weekend to work on their closings. And it's certainly, if I were on the prosecution team, I'd be asking for that. And let's just start fresh. Give us that opportunity to put it all together. How
long do you expect the closing arguments to be?
It'll be long. It'll be at least 2 hours, 2.5, maybe 3 hours. Their initial close, certainly it'll be long. It wouldn't surprise me. You know, what they try to train you and teach you, and you know, for me, common practice is, you know, you want to maintain the jurors' attention during this critical part, because you are asking them to, you know, you're summarizing now the evidence that they've heard and seen. You know, an opening statement, it's a theory. This is what I plan to present. This is the path I plan on leading you down. Closing is a lot different. This is what we showed you. Here's what the evidence showed, and here's how it relates to the elements that we're required to prove. And remember, they've got 3 charges that they have to kind of walk through. And so, you know, that I know, given the nature of this case, that they're going to take their time, and they should, because each element is important. And if it were me, I would want to make sure the jurors felt like they had a plethora of evidence for each element that I was trying to prove. And then ultimately, obviously, defense will have their turn, and then there'll be a rebuttal close, is what it's called, where the prosecution, because we've got the burden of proof, the prosecution gets to have the last say, last chance to kind of make maybe counterpoint whatever the defense draws. So I thankfully right now my Monday schedule is wide open. So I'm hoping they stick to closing statements on Monday, because I plan on gluing myself to the TV and watching it.
You know, oftentimes these type of trials become textbooks for classrooms. Do you think this would be one of those trials that will be studied later on down the road?
Well, sure. I mean, you know, depending on what, you know, how you are watching the trial itself, I started watching it through, I think MSNBC, and they had a panel of people from defense lawyers and whatnot. And, you know, it's interesting to hear their take on things, and then I switched over and found it on C-SPAN, which I thought was a better channel because they were actually broadcasting it live. MSNBC was kind of intermitting taped and live, and I wanted to watch it live. And that's been, I mean, it's been, you know, for me, I'm a kind of a geek when it comes to this kind of stuff, you know, and listening to the various testimonies and the witnesses in particular, and the testimony that was given, and just relating it back to my own experience and trying, you know, cases of this, not maybe of this magnitude, but of similar circumstances, and just being able to relate as to why that the prosecutor's asking that question, and why, you know, that to me, you know, it's something, fun is not the right word to use, but, you know, for a person in my profession, it's watching your colleagues work and looking at how their style and how they present witnesses. And that's why I'm curious to see how they present argument. Because to me, that's where, if you've established a good rapport with the jury, that's where you really kind of seal the deal. And you really bring home why, in this particular case, this officer is guilty of whatever, you know, the 3 counts, or, you know. And the other thing that I'm interested in is which count are they going to focus on? Are they going to give each count equal treatment, or are they going to recognize, now that the evidence has come in, where their strongest argument lies, and really, you know, it's a kind of a catch-22, because again, you don't know how a juror is receiving that evidence. You know, you hope that they're receiving it the same way that you are receiving it. But I think I learned early on that, again, we're dealing with folks that are just ordinary, everyday citizens. They didn't have law school training. They don't have trial experience. And so they are receiving it based on their own experiences. And it's easy, I think, from a lawyer's perspective, as you're presenting these cases and this evidence, where I see it in my head, in my eyes, hey, look, this is so straightforward. This is going to hit you right between the eyes. It's going to be so easy for you to make the decision, not recognizing that they're not seeing it through the same lenses that I'm seeing. And that you really have to separate yourself, because if you don't, as the jurors, and they'll take some time to deliberate. But, one of I never really got all that stressed during a trial itself. In fact, I felt more at ease and comfortable. It's the minute that you sit down after rebuttal close and you can't say anything more, and the case is now left to the jury to decide. That's where the butterflies start leaping in my stomach, because you don't have any control anymore, and it's in the hands of these citizens to ultimately make the choice. And when you start thinking that it's a slam dunk and they shouldn't take 10 minutes, that's when they take 3 hours, and you really start freaking out.
Right.
You start. You pace. You can't think. It's an experience that's very hard to describe. But for those of us who have tried cases and been in that position, we've all felt that. And I know, that you take that and you times it by about 10 in this case, because it has such a national world. The world is watching. And so, it's been, like I said, it's been interesting an experience for me, because I've never tried a case where I've had 5 of my colleagues, take part of the case, and I've tried the whole thing myself. In this instance, you've got 5 essentially special assistant attorney generals trying this case, and they each take a part of it. And so they're each responsible for a couple of witnesses or an area. And that's unique, because I've never had that experience. It's been, it's me all day, every day.
We got some online comments, and I got quite a few more questions on. Big Rob said, did you watch any of the Fox coverage of the trial? Fox airing the trial? I'm not even sure if they're airing it.
I don't know. I found it on C-SPAN 2, I think, and I've kept my TV on that channel because
he was trying to be funny, DJ.
Oh, is he funny?
Oh,
listen, it's difficult when I don't have Big Rob's facial features to tell me that he's
he was throwing a jab at you about Fox,
Oh, was he? Okay.
Because you're a Democrat, you know what I mean?
Yeah, right. No, I have not tuned into Fox. I've been strictly C-SPAN.
All right. You got some online compliments here. DJ Jason says DJ Hilson for governor. Pastor Joe Lane said DJ Hilson for president. There you go.
You guys, that's very complimentary.
It's love is in the air, man. People love you, DJ. You. Question for you: with these expert witnesses, like the expert witnesses that came in from Los Angeles, do the state pay for them to come in, or they volunteer to do this?
No. Well, I watched. I was able to watch at least most of the direct examination of the sergeant from Los Angeles. And the prosecution, one of their probably 10 questions in was, now, you were paid for your services. Yes, I was. He was paid a flat fee of $10,000 up front. And then there was another almost $3,000 for trial. So he was paid. I was curious on the cardiologist that testified yesterday, and I didn't hear whether he was paid or not. I got to go back and see, because what I found fascinating is this guy, who obviously was very well respected in his specialty and profession. This was his first time ever testifying in court. He's not one of those guys that advertises they're an expert and is making a little side hustle, if you will, on top of his practice. He'd never testified before, but I know I have a good idea why the prosecution called him, not only because his testimony was critical as it relates to the cause of death of George Floyd, that it wasn't related to a cardiac situation. It wasn't a heart condition. It wasn't a heart attack. It wasn't anything to do with his heart that caused him to die, which I thought was really powerful testimony. And he delivered that message to the jury, I thought, very well. But what's interesting is that on top of his specialty and the titles that he holds at the University of Northwestern and the Northwestern Hospital, he also mentioned in his direct testimony that he's traveled across at least I don't know if you said world, but certainly the nation, giving seminars, being a convention or a conference speaker. And I got to believe that when they found this guy, that attracted them because, medical testimony is extremely difficult to deliver, especially if it's being delivered by somebody that doesn't normally talk about it in any vein, because it's very technical. The terms are not terms that your average citizen is going to hear or understand. The way this guy delivered it, though, I was impressed. I mean, I was really impressed. It was clear that he's comfortable speaking in front of people. He looked at the jury every time he answered a question, and he answered the questions in a way that was very common sense. He gave examples that were, people could relate to. And like I said, I was really impressed with the guy. And I thought the message that he delivered, certainly, I'd be curious to hear the jurors, how they felt that gentleman did, because because of how he was able to deliver that, he came across as very credible, very believable, and that that they would walk away going, yeah, you know what that guy said makes sense, and I believe everything he said. That's how I walked away from it, going, holy cats, he was good. And that was one I really wanted to listen to the cross-examination, because direct is often, you go through when you're prepping an expert witness, you're kind of going through, these are the kind of the questions I'm going to ask you. Here's what here's what we're going to talk about. So you're comfortable knowing what's coming. Cross-examination is a different animal. You don't know what's coming. And I wanted to see how he handled cross-examination, because witnesses will do well on direct and could fall apart on cross. But this guy seems so matter-of-fact, so smart, that I guarantee you there wasn't a question the defense attorney was going to ask that he wasn't going to be able to kind of answer. And even, it's always nice when your expert takes a question from the defense and says, well, you got it wrong, and here's why you got it wrong, and here's here it is. And I missed that, and so I really would like to go back if there's an opportunity to find it and watch that.
Well, I got a couple more online comments. This one's kind of long. The entire trial from Namet Rashid in Atlanta, the entire trial is a farce and a waste of taxpayers' money. Derek Chauvin on video took another human being's life. It's just that simple, and the world witnessed it. The country and world nationally saw that video. George Floyd was just fine physically before the knee to his neck by the officer with a long police record of brutality. My question and hope is for the police department to implement new policy that would terminate any officers with numerous citizens' complaint. Have you seen those kind of policies anywhere where an officer who get a bunch of complaints is scrutinized and eventually terminated because of the complaints?
Well, I think a good police department, a good chief or a good supervisor, whether it's the captain or lieutenant, that is aware of multiple citizen complaints about a particular officer, in a good police department, action would be taken. No, there's no question about that. I mean, it's no different than if I had citizens complain to me on multiple occasions about the conduct of one of my staff, one of my lawyers. It would be a dereliction of duty on my part if I didn't investigate that, look into that, and take action if necessary because of that. And good police departments should operate the same way. That if you have an officer that is receiving multiple complaints from different citizens who don't know each other, and you need to do something in order to correct that. Now, the difficulty that police departments run into that I don't run into because it doesn't affect me is, officers are unionized, and you go through all the various levels that are negotiated during, union contracts as to how you can approach disciplining an officer who's a union member. My legal staff is not unionized; they're at-will employees, and so I can take different action than a union person. And again, those are things that I think certainly need to, as we look at improving law enforcement, those are things that I think really need to be scrutinized and looked at and analyzed, and a determination made as to what level of due process is fair, not only to the officer but more importantly to the citizen that is going through all that. And so that's a level of conversation that's going to require, I think, a lot of conversation, because you're going to have the union organizations push back on that. You just are. They're going to push back on that. But in the same token, there shouldn't be multiple layers of protection. There just shouldn't be. I mean, a bad person is a bad person, and there should be multiple levels of protection in order for an individual such as myself or a supervisor to take action to either eliminate that bad person or take some significant corrective action. I'm a big believer in that sometimes folks get protected too much, and we need to do something a little bit better in order to allow corrective action to happen, because otherwise the behavior doesn't change, and we're worse off than we were before. So I appreciate the question, and I guess I can appreciate the sentiment as it relates to the trial, but again, we live in a country that has that rule of law, that due process that affords everybody that, whether you like it or not, everybody has those fundamental rights. And that's just the nature of our Constitution, quite frankly.
Okay, another online question, and this is from Beekaboo. She says, "Why is your office taking so long with cases?" And she's more specific. How do you feel knowing it takes 9+ months for a child molestation case to go to court? These child molesters should be off the streets. Are you aware of this, DJ?
Well, I mean, I guess I need to know specifics. You telling me those general facts doesn't really help me. But if you gave me a defendant's name, I could take a look and really let you know. I mean, again, my position has been that we want to make sure that we get these cases adjudicated as fast as possible. Now, the difficulty has been the pandemic. COVID-19 really put the brakes on a lot of things happening, and that isn't me telling the courts to put the brakes on. That's the Supreme Court telling the court to put the brakes on. So I have no control over that. I can't tell judges to ignore a Supreme Court order and take things to trial.
Are these molesters out on bond?
Well, again, I would have to know. I would have to know the defendant's name in order to look it up in the system to see exactly where it's at, where it's been, and what the direction is moving forward. Without that information, it's hard for me to answer that question. And
DJ, typically, if it wasn't a pandemic, how long would it take for a child molestation case to go to court?
Well, again, it just depends on the nature of the case itself. We've had cases where, and we're talking about child victims here, not adult victims. And we've had cases where, kids haven't been ready to go into court and testify. And we've given them an opportunity to seek professional help in order to get them to that point. We've had a lot of cases where defense delays, and unfortunately, even though we may be ready and object, the court usually acquiesces to the defense who says that we're not ready for trial and we need a continuance, and the court will grant those motions. Again, from our standpoint, my goal and what I tell my assistants is that we are going to do everything that we can not to be the cause of any delays. And the other aspect of it, we rely on certain things. So, for example, a lot of times in CSC cases, like I'm assuming we're talking about here, there's been evidence collected that needs to be laboratory and analyzed by our crime lab and our state police crime lab. I can't control the volume they receive and the time frame they give me in order to get that information back. And unfortunately, because of their limited resources, a lot of cases that have DNA pending get delayed because we're waiting on those results.
Wow.
And so, you know, do I want delays in cases? Absolutely not. Do my folks intentionally delay cases? Absolutely not. Are we subject to delays because of things outside of our control? Yes. I mean, I would fathom the guess that whatever this case is, there's some outside mechanism that we can't control that is delaying the case. Because, you know, ultimately our time is not a friend to the prosecution. Time is never a friend to the prosecution. And our goal is to try to get these in front of a jury as fast as we can, because we want to, again, provide justice to victims. We want to maintain an efficient court system, but, you know, we're subject to things that we can't control, and we do the best we can to maneuver through it.
Wow. Before we go to the next online question, I know you was going to educate us on the immunity that is applied to police officers on duty. Immunity. Yeah,
so qualified immunity is a state statute, and I think it's relatively typical across the nation. I think most states have a qualified immunity statute, if not all. And essentially, qualified immunity extends to law enforcement only in a civil capacity. So it doesn't eliminate any of their liability in a criminal. So if they're charged with a crime, qualified immunity does not. They can't use that. It only applies if they get sued civilly. And essentially, in a nutshell, qualified immunity gives the officer protection if the conduct in question was being done during the course of their duty, and it's reasonable. So it's not a blanket immunity. So, for example, if they violate a constitutional right, or their conduct reaches to the level of being grossly negligent, qualified immunity has the opportunity to be to not exist or to not be used. So it all relates to the conduct of the officer, and was the officer engaged in conduct in the reasonable course of their duties. If the answer to that question is yes, then they would be able to assert this qualified immunity, which would essentially protect them from civil liability or being sued civilly.
Now, we heard of cases where the police department is not able to talk to these officers for a period of time.
So a lot of it depends on typically so for example, let's take an officer involved shooting. Typically what happens is that the department will require a 24-hour period of time where the officer involved is not questioned. And again, I can't remember if I don't know that that's necessarily a state statute. It might be department policy. And then officers have just like any other citizen, have the right to say, I'm going to talk or I'm not going to talk, just like everybody else does. Now, there is one other special rule that applies to law enforcement and police, and that a department, like a sheriff or a chief, can give or offer the officer involved what's called a Garrity right. And the Garrity right basically indicates that you're essentially forced to talk. In exchange, that statement cannot be used against you in any criminal proceeding. So it's an ability to get a statement, but that statement then becomes meaningless for prosecution because we're not allowed by law to use it. I don't obviously, for a lot of reasons, I don't necessarily like the application of Garrity because it hampers our ability to, certainly get to the truth and justice. But again, it's something that I would hope that chiefs or sheriffs would consult with their local prosecutors about whether or not it's important to offer that protection or not. And whether or not there's a way to get there without offering that protection.
So there is more protection for police officers than there are for regular citizens.
Well, I mean, in essence, yes and no. I mean, the regular citizen can basically say, I'm not talking. But
that would be held against them.
No, I can't use that. I can't use the fact that somebody exercises.
They're going to look at you and presume that, okay, he's not talking to us now. He got something to hide. But Officer Joe don't have to go home for 24 hours, get his evidence together, and he's represented by the union.
Yeah, but again, Paul, it depends. For example, we've had several cases where we can't locate a suspect, or the suspect flees the state, and we don't get to talk to him for days, months, and weeks. And so I get what you're saying. I mean, certainly that level of protection of where you let the trauma subside a little bit for 24 hours before you even engage them, maybe that needs to be looked at. But certainly, in some respects, there are situations where citizens, rightly or wrongly, have the ability to remain silent. They have the ability to disappear, and we don't get a chance to collect their statement. Maybe not at all. Maybe not ever. And that, again, for me, from the prosecution side of things, I want as much information as I can get prior to making a charging decision, and certainly as I prepare a case for trial. And so I want people to talk. I want people to give statements. But again, the Constitution gives folks, those that are accused of a crime, the right to not say anything. And more importantly, that it's not held against them. So, for example, I can in trial ask Detective Joe, hey, when you went and talked to, suspect Smith here, he didn't want to talk to you. I can't ask that question because, again, people have the right to remain silent, and it cannot be used against them.
All right, go on. I've got a couple online questions. This is coming from Big Rob. If I do something that is questionable by law, I am arrested and placed into jail until the investigations are over and done. Well, then I go to trial. Why are officers who do something questionable, why are they not placed into custody inside of a jail first until the investigation is over, and then either go to trial or release? Benefit of the doubt, giving when you're on duty, have uniform on in comparison to a normal person on the street?
Well, certainly, in my view of the world, certainly if we know up front that an officer has committed an illegal act or committed a crime, absolutely, I think they should go to jail. And I can think of at least a handful of circumstances where I was called out to a homicide scene, and it turned out that the individual who was the suspect of that particular scene, there was good evidence to show that it was justified, and that citizen didn't go to jail because of that. So I get Big Rob's point, but my point is this: is that if a crime has been committed and we know that right up front, that person's going to jail. There's no question about it. If there's some question as to whether or not a crime has been committed, I don't believe in putting somebody in jail. So in Big Rob's example here, if in fact there's some question as to whether or not a crime was committed, I would be telling the investigating officers that Big Rob should not be going to jail until we can sort this thing out. Now, that's if I can get, that's if we're kind of notified up front, we can start having those conversations. So I appreciate his point. And from my standpoint, if we know you've committed a crime, you're going. Bottom line, I don't care what uniform you're wearing, you're going.
Should defense attorneys be privileged to internal affairs dockets of officers who are involved in investigations of a case they're handling?
Well, I think there's a mechanism for defense to get at those materials. Certainly, if defense becomes aware of, so for example, let's go back to what you originally were talking about, where in the beginning, where we have an officer that has several citizen complaints made against them, and that particular officer happens to be the investigating officer for their client, the officer in charge, let's say. There is a mechanism in place where the defense attorney could motion the court and say, hey, look, I think that there is material in this officer's personnel file that's relevant to my defense. And I would like the court to review that material. I would like the court to review that personnel file and make a determination as to whether or not in any of those instances are relevant for me to use in my defense of my client. And so there is, in my opinion, a method in order for that to happen. And ultimately, the court would conduct what we call an in-camera review, which would mean the court would take the information on top of probably the legal brief and the arguments made by both sides, and then take all that and review to determine whether or not there, in fact, is an incident in that officer's personnel file that would be relevant, that would be a relevant topic for the defense attorney to ask or to get into in the case, in their case. So I really, certainly the level of protection is a little bit higher than just getting the file and being able to use it willy-nilly. But there again, I think that we have to be somewhat careful as to what is relevant and what isn't relevant. And to me, the person that makes that determination is the judge. That's what they get paid to do. That's their job. They are the referee, and they need to take the law and make a determination.
I'll ask you this question because former Muskegon Police Department officer Zach Anderson, who killed, I believe, an unarmed black man, Julius Johnson. I think he was unarmed, right?
Chuck Anderson.
Chuck. Yeah. The same officer we knew had Confederate flags on his ride. We knew that he was caught with KKK materials in his house, just accidentally found this information. I wonder how much scrutiny, knowing this stuff is there. I don't know what his internal affairs docket looks like, but in light of those things, it feels just like and I know he did get hit. We saw he got hit, but how do we know it wasn't provoked? How was his case looked at to give some assurance to the Johnson family now that maybe everything was done fair?
Well, unlike a lot of these incidents, that particular one was presented to a jury. If you recall, the sister was charged with I can't remember if it was lying or R&O, and that whole incident was essentially laid out in that case in front of a jury, as well as and I was in the office at the time, but I certainly wasn't the elected, and I wasn't in position and wasn't asked to review anything. So, my knowledge was limited to the senior level management that did all the scrutiny, if you will, of that case. And it was picked over with a very, I guess, careful eye and scrutinized, and ultimately the determination was made. And I think a lot of it had to do with the video footage, even though it was dark, the audio, because the video also had audio of a neighbor's security camera that was actually pointing into the alleyway where the incident occurred. And like I said, all that material was ultimately presented during that criminal trial. Right. And she was found guilty of, and I can't remember if it was resisting or lying. I can't remember which one it was.
Yeah, I think it was perjury or lying to a police officer in the midst of investigation. But it's just that suspicious when you look at the officers in his history. Can you trust his judgment that he treated Julius fair when you know this guy, one, has a Confederate flag on his ride, undisputed. Two, you found KKK materials in his house, and he had numerous complaints against him. It's like, would I trust this man in a dark alley and I'm there by myself with him? Nah. Because if you ride around a Confederate flag already, you're already saying that, what you down with. It's just me, DJ. I know you wasn't prosecutor at this time. I'm just throwing these things out here because this is what the history the black community has.
Sure.
With law enforcement. Here's another case. Will Griffin died in police custody. City of Muskegon police. begging for help. Police officer mocked him, saying, "Oh, you're a tough guy," before you got in the cuffs. Mocked him, and he died going to the county jail. And nothing happened to the officer. He didn't get fired. He didn't get charged. And it's on video of him mocking Will Griffin, "Or you're a tough guy." And the guy telling him that I can't breathe. I need help, because they had maced him. Those things kind of like, it makes less confidence in the police. That's all.
Yeah, no, and look, I'm certainly not going to downplay any of that, Paul. And again, one of the things that I really stressed for me personally when I took over the office in 2012, 2013 is that I wanted to make sure that I immersed myself in the community that I served, that I reached out and made sure that I was accessible, that I was able to be visible, as well as, not be afraid to have conversations about this. And I think, and again, I don't know when that last incident, when that occurred, whether I was.
That was on the Chief Clodbecker, because Chief Clodbecker and I, we had a disagreement. Matter of fact, he had a radio show on our station. And when I told him I thought his officer was responsible for the death of Will Griffin, he stopped doing his radio show.
Oh, okay.
Yeah. And the Griffin family did win a lawsuit against the city of Muskegon, but I think the cop is still there. That's the thing. Like, the cop is still there. And while the police officers rolled down Wood Street close to Hackley Hospital, when this guy's saying, "I can't breathe, I need help." And it's just this whole pattern thing.
Sure.
DJ. I know we only got a few more minutes. We got some online questions. Maxwell McGuffey said, "What's your opinion, the recent legalization of marijuana and the disparities that is left on our Black and brown communities? The cities of Muskegon and Muskegon Heights was deemed by the state to be top 20 for marijuana conviction rate poverty. How do you plan to right the wrongs done by law enforcement and lawmakers during a very long war on drugs that locked up a lot of brown and Black men and destroyed their families? Do you feel apologies warranted? What do you plan to do as far as, I'm sure you probably mean as a prosecutor? I know we got expungement clinics. I know we got laws in place, but what are your plans?"
Well, I mean, as soon as the law became legal, I was very public with what I was going to do, and essentially what I did was I looked at all the pending cases we had, and if it fell within the parameters of the law, I dismissed them and removed them. I can safely say that I don't believe, and this has been true for a while, that we don't have a person in our jail right now that is in there for the sole reason of marijuana. I can almost guarantee that. I also indicated very publicly after the law changed that I would be willing to review any prior conviction that anybody wanted to bring to my attention. And certainly, I think now with the new expungement laws, and that the law particularly associated with marijuana, those convictions are going to be even more scrutinized and looked at, and there's going to be an ability to erase them from a person's criminal history. So I guess from my standpoint, I took what I thought was the logical approach, which was, if you've got a pending current case going and it fits within the new legalization, I'm going to dismiss it, which I did. If you want if you want a review of a prior conviction, just let us know and we'll review it.
And I know the public defender's office is doing expungement clinics, right?
Yeah, I mean, I think that's their plan, is that they plan on doing an expungement clinic. I just saw today, it was forwarded to my attention, that the Attorney General just released a new website that details the expungement law, I think with some frequently asked questions. And so that just got, I think that just got released today, because I received that email. So I think there's an effort on a lot of people's parts, including prosecutors, including myself, because Fred Johnson and I have worked together collectively on a lot of different expungement issues. He's really helped me when I've had folks reach out to me and we're able to kind of work around the old expungement law and help expunge convictions off of folks' records. So he's my go-to guy there. And he knows that I certainly support his efforts as well as it relates to the expungement clinic. So we're quite a team here as it relates to that.
That's good. Hey, when you get a chance, check out this documentary called Trial 4. If you haven't seen it on Netflix. I'm sure you got Netflix.
No, listen, you're going to have to talk to Mrs. Hilson about that. We've been unsuccessful in subscribing to Netflix. So that's a higher level family conversation.
Oh my God. Yeah, right. Okay. It comes with the T-Mobile plan. I don't know if you have T-Mobile. It's free with T-Mobile. So you might be a Verizon guy. So.
I have Verizon, buddy. I'm sorry.
That's the money. That's where all the money going to that Verizon plan.
Yeah.
Jay Kilgo says,
"Yeah, I saw that." And do we have time? And I know you got to go, but
yeah, we can go ahead. Go ahead. Yeah, we can go ahead.
Yeah.
If you don't mind.
So, you know, several months ago, I became part of a subcommittee of our statewide association made up of, in fact, I vice chair, I think I mentioned it a couple of times on the radio, vice chair, our police improvement subcommittee, Kim Worthy, the Wayne County prosecutor chairs, and there are about 5 or 6 of our fellow prosecutors that have worked over the last several months talking to a lot of different people, victims of police brutality, organizations like the NAACP. We talked to the police unions. We've talked to the Sheriff's Association, Chiefs of Police Association. We've talked to higher levels of government officials on this issue. And one of the things that we have, and we're working on our own recommendations to the governor as it relates to, or the legislature and the governor as to what we think needs to be changed. And one of the things is exactly what's being addressed here, that we're asking that a centralized database be created that would be accessible not only to law enforcement, also to the public. And when police and require departments to report to that database when there's police misconduct, so that we can eliminate what is being asked right here, which is, an officer is a bad apple in one jurisdiction, gets disciplined or fired, and then is able to somehow get hired in another jurisdiction and continue to be a bad apple. That's a practice that we can't afford to have anymore. And there is some change where now a department has to disclose why that officer has left that department to another department, if in fact they apply for a position. There's some wiggle room there. But what we're asking, one of the things that we're looking and exploring as one of our recommendations is this centralized database that the state would kind of oversee, but would be accessible not only to people like myself, but also to the citizens of the state, so that they can for themselves see if a particular officer that then maybe they're having a problem with is on what I would call the central registry. So that's one of the, so I agree with you. We can't have bad apples jumping from jurisdiction to jurisdiction. That just doesn't solve the problem. And the state really needs to come up with an answer and a fix in order to make that not happen.
All right. Last thing, and this is very personal, and I hope, I'm saying it publicly because I hope you do this. And I don't know if you have. I don't know if you have a conviction integrity unit in Muskegon County, but I pray that you do get one and go back and make sure that we don't have anyone sitting in prison doing a murder for a case that was probably questionable, and they might have pleaded to it because they didn't have the education or the representation. I don't know. I haven't seen any cases from Muskegon County that's been overturned or brought back or found new evidence. And I know our system is not perfect. So that leads me to believe there is somebody in prison that's there that probably shouldn't be there. And if we got one person there, it's too many. I've seen it. You've seen on Detroit how they go back and look at these cases and say, we're going to go back and make it right. I believe if anybody can make it right, it would be you, DJ.
Well, I appreciate that, and I agree with you. The one thing that keeps me up at night, and that would keep me up at night, is that if I prosecuted somebody that didn't deserve to be prosecuted, and I pride myself, and I'm human just like everybody else, but I pride myself in the fact that I believe throughout my entire career I have not done that. Now, if I did, I would absolutely be the first to admit my mistake and work to correct it. To answer your question directly, I would love a conviction integrity unit. I would love it. The problem is I've got to find the financial resources in order to do that, because really a conviction integrity unit should be separate, should be part of the office, but separate and distinct from the folks that are doing the day-to-day work. That's the integrity part of that unit. It's connected, but it's not connected. There's sort of a wall between that part of the office and the day-to-day operation. The one avenue that I have is the Attorney General's office. I certainly can refer cases to the Attorney General's office, where people can, certainly make a request of the Attorney General's office conviction integrity unit to look at cases and make determinations. But I'm telling you, if there's a pot of gold somewhere that would allow me to do it, I'd be all over it. That would be great, but somebody's got to convince that the nine-headed county commission that this county needs it and that they fund it, because that's where my funding source comes from them.
We're going to make it a priority. We got to lead by example. All right, I know you got to go. Thank you so much. Sorry for these tough, hard questions.
Listen, man, I expect nothing less, and I appreciate it, Paul. I mean, I certainly hope, one of the things that I've always loved about this show and love doing it with you is the fact that you're not afraid to ask those questions, and I'm certainly not afraid to try and answer them. That's who I am. I may be an elected official, but I'm still DJ Hilson, and will always be DJ Hilson, and nobody will ever change that.
And I consider you a friend, and you know that these questions are not personal.
Yes, sir. No, listen, I certainly don't. And quite frankly, if I've done something and you're going to hold my feet to the fire, I'm going to accept that.
Well, I said that to you private. You're a friend, brother. It's certain things we don't have to go public with. You know what I mean? But you know.
Yes, sir. Yes,
Thank
sir.
you so much, DJ, man. Send your blessings to the family, man.
I will. It's good seeing you, even though it's virtually, my friend, and I appreciate being able to do this remote.
All right. Take care. God bless.
Yes, sir.